This video was created and brought to you by ManageMax. We manage condominiums, HOAs, manufactured housing and apartment communities throughout Southeast Michigan. We're a growing company, and maybe we'll get to your area soon if we're not there yet. We create these videos to share industry insights with current and prospective clients. There will be an opportunity to connect with us at the end, so stick around to the end of the video. Now let's dive in. Picture this. Your community votes 60% in favor of requiring all residents to join an expensive private club. Sounds democratic, right? Wrong. In Michigan, this exact scenario led to a lawsuit that changed everything for HOA and condo boards. Here's what you need to know to protect your community from making the same costly mistake. I'm here to walk you through a real case that every board member needs to understand. The Brusher versus Bay Harbor Yacht Club decision shows us exactly when majority rule crosses the line and how boards can avoid expensive legal battles. Here's what happened at Bay Harbor. This luxury resort community in northern Michigan had a yacht club where membership was mandatory for condo owners. The original agreement promised owners equity in the club by 2006 with capped dues and clear opt-out rights. But when the club needed changes for liquor license, everything shifted. The developer pushed through an early transfer in 1999, 7 years ahead of schedule. Over 60% of the members voted yes, thinking majority rule meant that they could change the deal. They were wrong. The Michigan Court of Appeals was crystal clear. You cannot vote away someone's contractual rights, even with a supermajority. The original membership plan was a binding contract, and those who opted out had every legal right to do so. The takeaway for your board: before any major vote that changes existing agreements, ask yourself, are we trying to override individual rights that were promised in our governing documents? If yes, proceed with extreme caution. The Brusher case hinged on one thing. The membership plan language was crystal clear about opt-out rights. This clarity saved the dissenting owners from being forced into an agreement they never made. But here's what I see too often. Governing documents that are vague about amenity obligations. Is the pool membership mandatory? Can golf course dues increase without limit? What happens if the fitness center changes ownership? Many communities don't own their amenities directly. Their clubhouse, pool, or tennis courts might be owned by a separate entity with separate rules and separate financial obligations. If your residents are required to join or support these amenities, those obligations must be spelled out clearly in your governing documents. Ambiguous language doesn't just create confusion, it creates lawsuits. And legal battles over unclear documents are expensive for everyone involved. The Bay Harbor developer thought the early transfer made business sense. Maybe it did. But the court made something very clear. Business convenience doesn't trump legal obligation. Even when majority sees financial benefits in changing course, those benefits cannot be imposed on residents who agreed to different terms, especially when those terms were a material part of their property purchase decision. For your board, this means thinking twice before rushing into changes, even profitable ones. Ask, what did our residents originally agree to? And are we honoring those commitments? Remember, people buy into communities based on specific promises. Changing those promises midstream, even with good intentions, can expose your association to significant legal and financial risk. Here's what you can do right now. Review your community's governing documents with fresh eyes. Look specifically for any language about amenities, mandatory memberships, or financial obligations to separate entities. If you find vague language or unclear obligations, address it before it becomes a problem. And if you're considering any changes to existing agreements, especially those involving member rights or financial obligations, get legal guidance before you vote. Clear documents and proper legal guidance aren't just good governance. They're your protection against expensive disputes that can divide your community and drain your reserves. If you found this perspective valuable, we invite you to connect with us. Facebook viewers, like our page and follow us for regular updates. Feel free to message us directly with your questions or community challenges. Instagram viewers, hit follow and feel free to DM us with your questions or community challenges. YouTube viewers, subscribe to our channel and check out the video description for helpful links. Visit our website to discover our thought leadership content, books, and resources that can transform your community management approach. Whether you're dealing with the challenges we discussed today or other community issues, we're here to help. Thanks for watching, and we'll see you in the next video.